if you have a parent that's in the US, they entered without inspection, and you want to know what you can do to get them status, well, this video is for you. It's an update to my past video on this same topic, but we're in 2025 and the immigration landscape has changed. So the advice that I may have given 2 years ago may not be the same advice I give you today. So let's talk about what a parent that is in the US and entered without inspection may qualify for, and how you can help them get their green card. I am U.S. immigration attorney Lilian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. Even though it's changing, it's still there, and we will continue working within that system to help our clients get their green cards and citizenship. So, one thing that has not changed since my last video is that in order to file for a parent to get a green card in the US, so a child that's over 21 wanting to file for a parent to get a green card in the US, that parent needs to have legal entry in some way, right? They came in with a visa, they came in with parole. There has to be some form of legal entry into the US for them to adjust their status in the US. But that's not what this video is about. This video is for everyone else. The people that did not enter with inspection, that did not enter with a visa, they did not enter with parole, but they are physically in the US. Let's talk about that. First thing you need to know is that as a child that's over the age of 21, you can file an I-130 for your parent. That is allowed. You can file the I-130. The place that you have the issue is them actually getting a visa to the US. Because they entered without inspection, they are not able to adjust their status in the US. However, if they left the US, they could eventually get a visa to come back based on your I-130 application. Now, depending on how long they have been in the US without inspection, they may have accrued enough unlawful presence that they will have a 3 or 10-year bar before they will be able to get that visa. Now, if your parent has no intention of leaving the US for 3 or 10 years, depending on if they've been in the US for over 6 months, but less than a year, or over a year. So that's the 3 if you've been in the US for less than a year, but over 6 months. And then 10 years if you have been in the US for over a year. All right. So in those situations where your parent does not want to be outside of the US for 3 years or 10 years, what other options are there for them? So, like I said, you can file the I-130. The issue is the visa. So, you may be able to still get a visa for your parent if they have a parent, so your parents, so your grandparents are in the US and they are green card holders or US citizens. In those situations, your parent may still be able to get that visa if they have to leave the US. So let's talk about how that is possible. There's a specific waiver called an I-601A waiver. This is for people that have unlawful presence in the US. Okay? Your parent, because they entered without inspection, has unlawful presence. So because they have that unlawful presence, you will need to file an I-130 for them, but then they need to file that I-601A waiver if they have no intentions of remaining outside of the US for 3 or 10 years. Okay? So that waiver requires them to either have a US citizen or permanent resident parent or spouse in order to get the waiver. And that parent or spouse has to suffer extreme hardship if they were not allowed to remain in the US, or if they had to move with the child. In this case, if it's the parents, if they have to move with their child, or if it's the spouse, if they have to move with their spouse outside of the US. This waiver is so powerful. It has brought people together, people that are in the US that have no options and feeling like I have a child that's a US citizen that can file for me, but I have a parent that is a US citizen, but if they file for me, it's going to take like 10, it's going to take 10 years, and then I still have to leave the US. Well, you have the option of filing a 601A waiver based on the parents, right? So your parent has the option to file a 601A waiver based on their parents. And this is where people kind of get annoyed with the waiver, because why, as the child, can you not be the qualifying relative for the waiver, right? You are a US citizen child. You may suffer extreme hardship if your parent had to leave the US. However, USCIS does not recognize that, right? You, as the child, cannot use your extreme hardship for your parent's waiver. So really want to make that clear. It sucks. It really does. But it's one of those things that people sometimes make the mistake of filing the 601A waiver, not realizing that they do not have a qualifying relative. So the only qualifying relatives for a 601A waiver is a parent or a spouse that's a US citizen or permanent resident. This is really key here. So if your parent has parents that are US citizen or permanent resident, they can apply for the 601A waiver. If your parent has a spouse that is a permanent resident, they can use that spouse for the 601A waiver. And we have seen that where the spouse just got their green card and it's going to take them 5 years to get their citizenship. And in the meantime, the spouse that does not have any status is just waiting, but they have a US citizen child that can file for them. Well, my thing is always go ahead and have your child file for you, because you can still use your non-US citizen spouse as your qualifying relative, okay? Because they have their permanent residency. So that is one option. If your parent does not have a qualifying relative for the waiver, the question becomes, can they get a qualifying relative for the waiver? And this is where, the creativity of immigration law comes in, okay? If your parent is in the US, they are married, but their spouse also does not have a status, but they entered with inspection, right? They entered with a visa, they entered with parole, and they married your parent before you turned 18. Now you're 21. Guess what? You can create a qualifying relative for your parent by filing for your step parent. Okay, remember I said if they got married before you turned 18, they will qualify as your step parent for immigration purposes, which means you can file a green card application for that step parent that entered with a visa, that entered with parole. So in doing that, once they get their green card, you have now created a qualifying relative for your parents. I know, I know it is a roundabout way of getting there, but with immigration law, sometimes you have to be creative in the way that you get to the result that you're looking for. So in this situation, that step parent that did not have status can now get status through you, and then your parent can get status through them because now they have a qualifying relative for the waiver. So really important to look at all the options available to you and not just look at yourself, right? Yes, you as the child are not a qualifying relative, but is your parent married? Right? Does the person they're married to have a green card or citizenship? Then they can apply for the waiver. But if they do not have any status, they're married, but that spouse does not have any status, can you get the spouse status and then be able to have a qualifying relative for your parent? That is a question that you need to answer, but it is a way that you can basically create a qualifying relative for your parent. Now, if your parent is not married and does not have US citizen parents or permanent resident parents, then you may want to look at, are you in the military? If you are in the military, you can apply for something called military parole in place. This will basically, if approved, give your parents a legal entry into the US. So now you can apply for their adjustment of status in the US without needing the waiver at all. Okay, this is only for military. Okay, if you are not in the military, this option would not be available to you. But if you are in the military, you can look into military parole in place that will then give your parent legal entry, and then that way you can apply for their adjustment of status and be able to get them a green card. Here's another thing about the military parole in place. The child does not have to be 21 to get their parent military parole in place. So let's say a parent has two children. One is over 21, but is not in the military, but the other one is 19 and is in the military. The 21-year-old wants to file for the parent, but they don't have a qualifying relative for a waiver, so they feel stuck. The 19-year-old is in the military and can file a military parole in place for that parent. Once that military parole in place is approved, guess what? The 21-year-old can now file an adjustment of status for that parent. So the person that does the military parole in place does not have to be the same child that files for the adjustment of status for the parent. So I just wanted to mention that because I do see that a lot, where in a family, maybe only one person is in the military, but they're not old enough to file for the parents. However, your age for military parole in place does not matter. It just matters that you are in the military. So that is an option that could work if that parent has a child that is in the military. Now, if none of those options are available for the parent, you may want to then open up, right? Expand your worldview of what other options may be available for your parent to be able to adjust in the US. So they may, depending on their situation, you may want to look into, have they been victims of a crime or victims of trafficking? You may want to look at a U visa for victims of certain crimes, including domestic violence crimes. So you want to look into that, see if they qualify for it, because that is a way that they can get status in the US without needing to leave the US. Okay, that's a U visa. A T visa is for victims of trafficking. This includes labor trafficking, sex trafficking. It's not limited to your traditional idea of what trafficking is. Depending on a relationship, there could be trafficking in a relationship. In a domestic violence situation, there may be trafficking involved. So those are all things you want to look at and look for options outside of the family base. So if the family base is not working because there's no qualifying relative and there's no one in the military that can do the parole in place, that doesn't mean you're out of options. It just means you need to expand your views, okay? You need to expand what options are available. So if there's no family option, you need to look at the U visa and the T visa. If they were married to a US citizen or a permanent resident, you also want to look at VAWA if they were victims of domestic violence. This is physical violence, psychological, financial, sexual, like all of the abuse, okay? Not just did they get hit, right? Because sometimes we limit our understanding of violence as if it's just physical. It is not, okay? So you want to explore all of those things before you basically say, okay, there's no options there. All right. So you want to explore all of those options for your parent. Now, with everything going on right now, you may be wondering, what if they get picked up by ICE and are put in deportation proceedings? What do I do? Well, in that case, if your parent has children that are under the age of 21 that will suffer extreme hardship if they were to be deported, right? If the children were to stay in the US without the parent, or if the children were to leave the US with the parent, and they would suffer extreme and unusual hardship, then they can apply for something called cancellation of removal. However, here's the biggest however. Your parent must have been in the U.S. for at least 10 years before they were put in deportation proceedings. Okay? Before they were put in removal proceedings, they had been in the U.S. for 10 years. That is really the key here. So that is a way that they will eventually get a green card if they can prove to the judge that they have this qualifying relative, which now includes children. Right? The 601A waiver does not include children as qualifying relatives, but cancellation of removal includes children as qualifying relatives. So again, this is only an option if the parent is put in deportation proceedings. So it's really important that you do not make that your top option. Okay, this is a backup option if nothing else works, or if they end up in deportation proceedings. You want to make sure that you know this is an option, but you can't put yourself in deportation proceedings. ICE has to do that, okay? But if the parent does end up in deportation proceedings and has a qualifying relative, a child that's under the age of 21, or a spouse that is a U.S. citizen or a permanent resident, okay? The children have to be U.S. citizens or permanent residents. I should mention that, okay? But if they do have that qualifying relative for the cancellation of removal, they can apply for that in removal proceedings with the judge. And if it's approved, they will get a green card through that process. And those are all the ways that a parent that entered the U.S. without inspection can potentially get a green card, either through having a child that's a U.S. citizen file for them and having a qualifying relative for a 601A waiver, or the child can file for a step parent and create a qualifying relative for their parent. The child, if in the military, can file military parole in place for the parent and then file a green card application for the parent once that military parole in place is approved. And then finally, if none of the family options apply, you can look at a T visa, a U visa, a VAWA, if they fit into any of those. And if they have the unfortunate situation of being put in deportation proceedings, they may be able to qualify for cancellation of removal if they have been in the U.S. for at least 10 years before being put in deportation proceedings, and they have qualifying relatives for the cancellation of removal. And children are qualifying relatives for the cancellation of removal, but children are not qualifying relatives for the 601A waiver. If you want more information on the 601A waiver, I do have a video on my channel where I break it down for you, who's the qualifying relatives, what counts as extreme hardship. So make sure you watch that video as well. Now, with everything going on with, ICE and U.S. immigration and all of those things, one thing I will mention is you want to get a consultation. You want to speak with an immigration attorney before you take any steps, especially if your parent is subject to the registration requirement. You want to discuss that with an attorney first before doing anything else. And you want to make sure that your parent actually qualifies for the benefit that you are applying for before you apply. Because again, every single application you file with USCIS for your parent is given information to USCIS about your parent, about where to find them and all of that. You want to make sure that they qualify for the benefit that you're trying to get for them. If you are trying to figure out what option is actually available for your parent and what you can do to help them, please feel free to schedule a strategy session with me. This is a free 15-minute session where we discuss your parent's case, their situation, and figure out what options are available to them, and if we can help you make their green card goals a reality. You can schedule that strategy session by going to my website, lilylegal.com, and clicking on Contact Us, where you can pick a date and time that works best for you for us to discuss their situation.